Welcome to this deep dive. We take your sources, unpack them, and hopefully give you the core insights you need.
That's the plan. And today we're digging into something pretty specific in U.S. patent law.
Right, we're looking at the MPEP, the Manual of Patent Examining Procedure.
Yes, specifically Chapter 2100, which is all about patentability.
And within that, we're zooming in on Section 2124. The title is kind of intriguing. Exception to the rule that the reference must be prior art.
It is. It sounds a bit odd at first glance, doesn't it?
It really does. I mean, my understanding, and probably most people's, is that when you file for a patent, the examiner looks at prior art, stuff that was already known before your filing date to see if your invention is new and non-obvious.
That's the general rule. Absolutely. You compare the invention to the state of the art before the effective filing date.
So this section 2124, it's saying sometimes examiners can use references published after the filing date. How does that not, break the whole system? It feels like judging yesterday's race using tomorrow's stopwatch.
Huh. That's a good way to put it. But no, it doesn't break the system because of how these later references are used. They aren't used as traditional prior art to say, look, someone invented this after you filed, so yours wasn't new.
Okay. So what are they used for then?
They're used to understand the context, the sort of scientific baseline that existed at the time you filed. Think of it like finding an old diary entry later that confirms what the weather was actually like on a specific past date. The diary entry is new evidence, but it speaks to the past conditions.
I see. So it's not about what happened later, but using later information to clarify what was true back then? Like, was the claim scientifically plausible at that moment?
Exactly. It helps examiners check fundamental things about the invention based on the understanding of science and technology as it stood on the filing date. It maintains integrity.
Okay, that makes more sense. Can we get into specifics? The MPEP usually cites court cases to back this stuff up, right? What are some situations where this actually happens?
Absolutely. The section lays out several key scenarios, often referencing those important cases. One big one comes from In re Corneal. It's about showing that making the invention would have required undue experimentation at the time of filing.
Undue experimentation. That means, like, way more work than someone skilled in that field would normally expect, more than just routine tweaking.
Precisely. It's asking, based on what was known then, would figuring this out have been a massive research project in itself? A reference published later might contain analysis or data proving that, yes, achieving what was claimed back then would have been incredibly difficult, maybe bordering on impossible, without extensive, non-routine work.
Got it. So the later reference provides proof about the difficulty level at the time of filing. What else?
Another situation, this one guided by In re Rayner, is about figuring out if a specific claim parameter, say, a temperature range or a specific percentage, was actually critical to the invention working, again, at the time of filing.
How would a later reference show that?
Well, imagine your patent claims an invention works only between 90 and 95 degrees Celsius. A paper published a year later might study the same process and show, actually, it works perfectly fine from 70 up to 120 degrees. That later evidence suggests your narrow range wasn't truly essential based on the underlying science, which presumably hadn't changed in that year regarding that basic function. It undermines the idea that the narrow range was critical back when you filed.
Okay, so it questions the necessity of the limitations the inventor put in the claim based on the underlying scientific reality.
That's the idea. Then there's In re Marzocchi. This allows using a later reference to prove that a statement made in the patent application itself was factually inaccurate at the time of filing.
So not that science changed, but that the inventor got a fact wrong in their own document.
Exactly. If the application stated, say, material X always melts above 500 degrees, but a later reliable source shows that actually it was well known at the time of filing that material X sometimes melts lower, that later source can be used to point out the inaccuracy in the original application.
Seems fair. It keeps the application honest about the baseline facts. Any others?
Yep, utility is another one. Based on In re Langer, if there are serious doubts that the invention could actually do what it claimed to do at the time of filing, a later reference might provide evidence confirming that lack of utility.
So if you claimed a perpetual motion machine and a later physics paper explains again why they're impossible based on laws known since forever, that paper could be used.
Kind of, yeah. It's about showing the invention lacked a credible function based on established scientific principles understood at the time of filing. The later reference just helps demonstrate that lack of utility wasn't some new discovery, but was inherent back then.
Okay. And there was one more specific case mentioned.
Right. In re glass, this deals with indefiniteness, meaning was the claim language itself unclear at the time of filing?
How would a later source show that?
Imagine a claim uses a technical term, maybe something like substantially spherical. If a publication that came out shortly after filing shows that within that specific field at the time of filing, the term substantially spherical had wildly different interpretations or no accepted meaning that could be used to argue the claim was indefinite. People skilled in the art wouldn't have known what was actually covered.
Okay, wow. So these exceptions cover quite a range. Feasibility, criticality of limits, factual accuracy, basic utility, and clarity of the claims themselves.
They do. And the common thread, the really crucial point, is that they all relate back to understanding the state of technical knowledge, the scientific facts, as they were accepted or understood at the effective filing date.
Not about bringing in brand new science discovered later.
Absolutely not. That's the line. Which leads us nicely to what these references cannot be used for.
Right, the boundaries, what's off limits.
Well, the big one is you can't use them just to show how the general state of the art progressed after the filing date. You can't say, look, things got better, technology advanced, so now the original invention seems simpler. The comparison point is fixed at the filing date.
Makes sense. Keeps the goalposts from moving. What else?
They also cannot be used to evaluate enablement or written description under the patent law, specifically 35 U.S.C. Section 112A.
Remind us what those mean again.
Sure. Enablement is whether your patent application teaches someone skilled in the field how to actually make and use the invention without undue experimentation. Written description is whether the application adequately describes the invention you're claiming, showing you were in possession of it.
Okay, and why can't later references be used for those?
Because enablement and written description are judged based on the adequacy of the disclosure in the application itself, as understood at the time of filing. You can't use a later discovery to argue that the original instructions were insufficient. It's like judging a 1950s car manual. You judge it based on whether a 1950s mechanic could use it, not whether it includes details about OBG2 scanners developed decades later.
So a later paper revealing a better way to make something doesn't mean the original patent failed to enable it back then.
Correct. The Amgen v. Sanofi case is relevant here. The court noted you might use later references carefully, perhaps to show that the original disclosure didn't provide enough specific examples, species, to support a very broad claim covering a whole class, genus of things, suggesting the inventor hadn't truly enabled the full scope at the time. But you couldn't use them to rewrite what was generally known in the field after the fact. It's a subtle distinction.
Yeah, that is subtle. Insufficient examples versus changing the baseline knowledge.
Precisely. Now, there's one more twist, another permissible use, but it's not about rejecting the claim directly. Post-filing references can sometimes be used as evidence of the level of ordinary skill in the art at the time of the effective filing date.
So not as prior art, but to help establish who the average expert was back then, what they typically knew and could do.
Exactly that. It helps set the context. Who are we measuring the invention against? The MPEP mentions ex parte Ehrlich for this. A reference published later, which wasn't prior art itself, was apparently used just to show the general knowledge and skill level prevalent in that field around the filing date. It's an evidentiary tool for context.
Right, it defines the audience, essentially, the hypothetical person skilled in the art.
You got it. So pulling it all together, these Section 2124 exceptions exist to let examiners use later published information, but only in very specific ways, primarily to confirm or clarify the technical realities and understanding at the crucial moment of filing. It allows a check on feasibility, accuracy, utility, clarity, fundamental patentability requirements.
It really is a balancing act, isn't it? Protecting the inventor's filing date advantage while ensuring the patent system isn't granting rights based on flawed assumptions or unclear claims.
That's a great way to summarize it. It ensures the examination is grounded in the technical reality of the filing date.
Well, this has been incredibly helpful. It takes a section that sounds counterintuitive and really clarifies its purpose and limitations.
Glad we could unpack it. And remember, the key takeaway is, the general rule is prior art must predate filing. Section 2124 provides very specific narrow exceptions where later references can illuminate the situation at the time of filing for issues like undue experimentation, claim criticality, accuracy, utility, indefiniteness, or even just establishing the level of skill back then.
And crucially, it's not a backdoor to use later scientific advancements against the inventor.
Definitely not. And, this deep dive is just one part of a larger project we're involved in.
That's right. We're working through the entire manual of patent examining procedure, section by section, creating these audio summaries.
Yeah, the goal is to make this complex material a bit more accessible. This whole series, including today's look at MPP 2100, specifically Section 2124 on patentability exceptions, was really spearheaded by Mike Shepard, the creative director. His vision is driving this effort to provide clear educational overviews.
Absolutely. And as always, a necessary disclaimer.
Right. Please remember this summary used AI tools like ChatGPT and Notebook LM in its preparation. It might have errors. It's for educational info only, definitely not legal advice.
For the real deal, you need the official MPEP text, or even better, advice from a registered patent practitioner or qualified instructor.
Couldn't agree more.
Okay, so to leave our listeners with something to chew on. Thinking about these exceptions and how they focus on the state of knowledge at the time of filing, how might a really savvy inventor or attorney strategically use their understanding of that contemporary knowledge landscape when drafting and prosecuting a patent application? How does knowing these rules potentially influence filing strategy?
That's a great question to ponder.